Kia ora mai tātou, tēnā tātou katoa. Members, the House is resumed. The second reading of the Judicature Modernisation Bill. Jacinda Ardern was speaking and has 7 minutes remaining to speak should she choose to avail herself of that opportunity.
Thank you, Mr. Speaker, and I've put all the members to the yard because they all wanted to hear about my views on the diversity within the judiciary, or perhaps our what should be our aspiration for greater diversity within the judiciary, because the Judicature Modernisation Bill, amongst many other things, does set out a retirement age age of retirement for judges, and the question that I was raising was my concern that was very eloquently summarised in a piece by Kitcher and McClellan in 2000 at the end of at the beginning, of 2013, where she pointed out that at present 72% of New Zealand's judges are male, 72%, 28% are female, and that a Court of Appeal, for instance, 80% are male, District Court, 69% are male, and before anyone makes the argument around meritocracy and availability of female lawyers, the New Zealand Law Society magazine calculates that 3,463 women are eligible for appointment as judges. So I just thought I would put out that challenge. And gender, of course, is not the only diversity we should be ensuring we have on our judiciary. There are no statistics on ethnic diversity in the judiciary. I've even asked for that. I'm keen to ask again, because the experiences, the life experiences, the cultural competencies that we bring to the judiciary are incredibly important. And of course there's training that tries to teach all of those things, but I think ensuring that our judiciary has a wide range of experience, of course, as well as legal expertise, is something that we should be constantly mindful of. So I wanted to raise that. Coming back to the Judicature Modernisation Bill, the Law Commission was very clear in their key recommendations in the report they issued in November of 2012 that the primary purpose of the review they were conducting was a simplification and modernisation exercise. In fact, they've even stated that the primary purpose of the review was to modernise the laws under which New Zealand's primary trial and appellate courts are constituted. These laws determine how the courts are set up, how judges are appointed, their jurisdiction, rulemaking powers, and the procedures by which they administer justice. Given the fundamental role of the courts in society, it is imperative that this legislation is clear, accessible and intelligible. And they then set out the ways in which they've consolidated the acts in order to achieve those goals. Accessible is the one word that stood out to me when I read that. Yes, simplifying the language by which our judiciary is governed and is structured is incredibly important. But accessibility can be measured in many ways. I recently read, as I'd hope other members in the House would, the Ethel Benjamin address by Her Honour Justice Helen Winkleman, the Chief High Court Judge, which was only given in November 2014. When she talks about the accessibility of our justice system, she quotes Lord Neuberger and says that accessibility has a number of components. First, a competent and impartial judiciary. Secondly, accessible courts. Thirdly, properly administered courts. Fourthly, a competent, honest legal profession. Fifthly, an effective procedure for getting a case before the courts. Sixthly, an effective legal process. Seventhly, effective execution. Eighthly, affordable justice. Now, there are many elements within that we could discuss and pick apart, but I think the element that Justice Van Winkleman rightly raises within her address is the affordability element. She goes on to state that there are indications that far from being viewed as a democratic institution, civil courts are, for policy purpose at least, regarded as a luxury service for which users should pay. There is a new language that is used in connection with courts. People who come before the courts are called customers. Judges and lawyers are referred to as stakeholders. District court centres are referred to as franchises. We are now to understand that we are part of a market for justice services and our product is being marketised. Now, I know that there was some discussion in the first reading of this bill around that concern, and it was shared. David Parker raised it. There was some then discussion by the Attorney General acknowledging that concern. And the reason I raise it now is that if we are to maintain that very important principle of access, we must be constantly mindful of simple things like court filing fees, whether or not someone is able to access a lawyer, and that's something that we have considerable concern about. Part 4, for instance, of this bill responds to the Law Commission's report, Aspect of Damages, the Award of Interest on Money Claims, creates a single statutory system for the awarding of judgments. It ensures that interest placed on awards is compounded rather than simple interest. Raises an interesting point. Currently, the interest rates that apply to the Judicature Act are much lower than the rates that apply to legal aid debt, which sits at 8%. And anyone who accesses it is told that they may have a debt collector who may recover legal aid debt. Mr. Speaker, I raise this because any attempt to modernise the rules that govern our judiciary are to be applauded and welcomed because of the principle of accessibility. But we should make sure that we never lose sight of how well that in real terms that is playing out for citizens and civil society. And when the judiciary starts to raise that self-representation is perhaps demonstrating an increase in self-representation is demonstrating an issue within our court system, and that the court costs are becoming prohibitive to access justice, particularly within the civil courts, we should listen. We should listen. And so I wish to use this opportunity in the second reading to raise that. And in the third reading, I'd also like to come back to some of the other elements of the bill, like, for instance, electronic technology, which there's greater movement towards in the justice system generally. But there have been examples where centralisation of the registry courts, for instance, in Auckland, has not led to efficiency or cost savings, but actually to mistakes, errors, lost files, greater inefficiency. We should not just simply move rapidly towards gains without ensuring that they're rolled out in a way that does not hamper an already extraordinarily busy court system and a heavily burdened justice system. There's much more that could be said, and I look forward to the opportunity to do that at third reading. Thank you, Mr. Speaker.